Are you worried the court might see you as an unfit parent? It's a real fear for many parents, even those who love their kids deeply. But in Illinois, unfit is a serious legal label, not something handed down for minor mistakes. I'm Jeff Hughes, lead attorney at Sterling Lawyers. In this video, we're asking the question that could decide your case. Are you at risk of being seen as unfit under Illinois law? Let's get one thing straight right off the bat. Unfit parent isn't a casual term. It's a legal determination with major consequences. Under Illinois law, a parent is considered unfit if they fail to provide for their child's basic needs or safety. The Illinois judges and family courts look for patterns of serious misconduct or neglect, not isolated events. There are common grounds for unfitness in Illinois. Courts look at several factors when deciding if a parent is unfit, and here are the most common. Abandonment, leaving your child without meaningful contact or support for a significant period. Neglect, failing to provide food, shelter, medical care, or education, especially if CPS is involved. Abuse, physical, emotional, or sexual abuse of the child or another family member. Substance abuse, whether that be drug or alcohol use that endangers the child or impairs your ability as a parent. Untreated mental illness, having a mental health condition that, if left untreated, puts the child at risk. Criminal convictions can be grounds for unfitness, especially those that are serious crimes, or those involving violence or child endangerment can be grounds for unfitness. Repeated cruelty or unsafe conditions that expose the child to ongoing danger of harm. Illinois courts are focused on the child's best interest. They look for patterns of behavior, not single mistakes. And here are the behaviors that raise the most red flags. Substance abuse. If your drug or alcohol use affects your ability to care for your child, the court may restrict your parenting time or require treatment. But if you get help and show progress, you can regain that trust. Our firm had a client once. I'm going to call him Marcus for purposes of this video, and he really struggled with alcohol, constantly drinking and intoxicated all the time. But he recognized it. He knew he had a serious problem, and he entered alcohol outpatient treatment after a CPS report was generated on him. But 6 months later, with documented sobriety, the court began to restore his overnights and his time with his children because he took responsibility and sought treatment. The issue isn't having a past, it's how you handle the present. Another is untreated mental health issues. Having a diagnosis isn't disqualifying, but ignoring treatment or letting your condition put your child at risk can impact custody. Another is domestic violence. Any history of abuse, even one incident, can shift the judge's view and can cause a parent to lose all placement time with their children other than supervised. Courts are required to consider the safety of the child and other household members. Another is neglect or unsafe conditions, failing to provide basics like food, shelter, or medical care, especially if there are documented reports or repeated concerns. Those can add up to a finding of unfitness. Also, along with that, CPS involvement or police reports, those can be dramatic to a judge, and they are strong evidence for the court to consider. Now let's pause for a second, because this is where a lot of parents can get a little confused on what is considered unfit and what is not considered unfit. Arguing with your ex, that is not unfit, even though they may say it is. Letting your child stay up late and eat a lot of junk food, that may not be great for him, but that's not unfit. Working 2 jobs and missing bedtime sometimes, still, that is not unfit. Even not paying child support. In Illinois, that is not grounds for unfitness. Remember, judges don't expect perfection. They expect protection. The law requires decisions to reflect what is in the best interest of the child overall. Now, if you're concerned or if something in your life feels a bit off right now, here's what you can do starting today. Document everything. Use a parenting app. Log your time. Keep records of meals, pickups, school events, and even text messages. Get support if needed. Counseling, recovery programs, parenting classes, all of it matters, not just for you, but for your court record. Stay professional, even if your ex isn't. False accusations happen. The court follows facts, not fear. Case in point, I had a client once, I'm going to call him Alex again for purposes of this video. He kept getting harassing texts from his ex. He never responded emotionally. He just saved everything. And when claims of abandonment came up, when she made those outrageous, bogus claims, his record told an entirely different story. And that won the day for the court because he had the documentation to support his testimony. At the end of the day, Illinois courts and judges come back to one principle: what is in the best interest of the child? And that means looking at relationships, the child's bond with both parents, stability, consistent routines and environments, health, physical and mental well-being of the child and parents, safety, protection from harm or danger, parental cooperation, that is the ability to work together for the child's benefit. If you're showing up, staying steady, and putting your child first, the court will see that. But what if the other parent is twisting the truth or trying to paint you as unstable? That is where it gets tricky and where you need to have a real strategy. In this next video, we will break down the 5 ways to protect yourself in an Illinois custody case. Don't miss it.